Mr. McNeil.
Ladies, I appear on behalf of the appellants with Mr. Philip Steer. My learned friend Mr. James Hart appears on behalf of the respondent.
Yes, thank you.
I'm sure your ladyships have all had the opportunity to read the...
We have, and we've taken it.
Take it as read, yes. What I propose to do then, by way of oral argument, is to just very quickly look at some of the documents and the pleading very quickly, by way of context. Then I will address the instruments, the European influenced instruments, in particular the Brussels Convention as applicable here, and the CJEU case law, which is at the heart really of the interpretation of that text. And then I'll say a bit more about each of the grounds in due course. I anticipate being through that hopefully by lunchtime, given I think we're listed for the day, aren't we? So,
We are.
indeed. So, assuming you've had the opportunity of reading and looking at the scales and arguments, I won't go through that in detail. If I can take your ladyships first to the claim form, because obviously it's important to look at how the case is put. So you'll find this in the core bundle.
And could you at some stage please give us the date of service? I know it was in 2021, but it would be helpful to have the date. Issued to 2020 and served at some stage in 2021.
That's right, yes. So looking at the core bundle, starting at page 78, you've seen the issue date, my lady, obviously. Starting at page 78 are the particulars of claim. And you'll see at page 81, paragraphs 14 to 16, a bit of background on the respondent, including its website of paragraph 14. Which is quoted, I'm sure your ladies have seen that already. We say at paragraph 15, it held itself out as a provider of overseas pension schemes to the UK market and promoted its experience with dealing with HMRC. And then we allege that it's...
do we have a date for this website entry?
No, we don't. It was probably a current one. It's not one which is historic in that sense.
These transactions, transfers took place in, what, 2014, 2015?
My lady, basically, yes, 2014 to 16, perhaps, yeah.
Right. So when you get on the website ground, is this the entry that you rely on?
My lady, yes.
But you don't know what was in place in 2014, 2015?
My lady, no.
Right, okay.
And on the same page, page 81, description of the important intermediary entity Montague Smythe, a company incorporated in Cyprus. Paragraph 18 is neither authorised nor exempt under the UK financial services law, and neither, we understand, is it authorised in Gibraltar, I think that's common ground, or in Cyprus. Nevertheless, Montague Smythe, acting by itself and its associates, including without limitation Mr. David Gale, engaged in breach of the general prohibition under section 14 of FSMA, and of the financial promotion restriction in breach of section 21 of FSMA by promoting, advising and arranging on pensions investments in the UK, targeting persons such as the claimants who accrued UK pension benefits. And in particular, Montague Smythe as associates promoted and or advised and or recommended and or arranged the transfer of pension benefits to QROPS with Castle, and further promoted, advised and arranged on investments in UCITS, regulated collective investment schemes, and corporate shares. So that's the introduction to Castle as product provider and Montague Smythe as intermediary. The joint venture between the parties is pleaded at paragraph 36. Introduced at 36. What we basically rely upon, of course, is we had quite detailed disclosure from the respondent under its own information management system, as described in paragraph 37. But we said that each of the claimants was introduced to Castle and to its QROPS, the pension scheme, through Montague Smythe. And Montague Smythe was identified in correspondence from Castle to each of the claimants as introducer, and Castle paid substantial fees to Montague Smythe in the capacity as introducer. Furthermore, Montague Smythe is expressly identified as introducer for each of the claimants in Castle's own customer relations information management system. It should be inferred that there existed an agreement or agreements, whether in writing or otherwise, and associated communications governing Montague Smythe's status as an introducer for Castle.
And this is a duly verified document on behalf of each and every one of the claimants?
Yes. And for your ladyship's note, I've been told that the date of service was the 19th of March, 2021.
It was Mr. Hart coming to assistance. Thank you very much. 19th of March. Thank you.
And paragraph 40 then particularises what we can say in terms of general terms. Castle charged substantial fees for its Equus and Metro QROPS, requiring a minimum investment of £50,000 and charging 1% of funds transferred as a setup charge, with a minimum fixed fee of £995 and an annual management fee of a further 1% of the funds transferred, with a minimum fee of £995. For transfers greater than £500,000, a reduced platinum fee of 0.5% applied. And therefore we make the point that it had greater detrimental impact on smaller transfers. It made additional deductions on each of the claimants' accounts for Montague Smythe's fees, IFA fees, sometimes describing Montague Smythe as the IFA, bank charges, stamp duty and courier fees. So obviously based on the documents we have and without sight of the terms between Montague Smythe and Castle, that's the pleading. Paragraph 88 going forward in the pleading. Page 95 at the bottom, under the heading Jurisdictional Governing Law. Asserting that it lies under the Civil Jurisdiction Judgment Act 82 Gibraltar Order, and the modified version of the Convention under that, and the provisions on consumer contracts under Articles 13 to 15, in particular Article 13.3. So, setting out our stall on jurisdiction under the consumer contracts test of the Brussels Convention. Then there are three bases of claim. I think my learned friend promotes my third basis as my main basis and deals rather shortly with my first two. The first one obviously is based upon joint tortfeasorship reasoning, paragraph 91 onwards. Obviously with Montague Smythe, but with other intermediaries as well. That this was an exercise in harvesting UK pensions. Taking the first named claimant, Mrs. Dooley, was a police officer and member of the, obviously, sometimes called gold-plated, defined benefit scheme available to members of the police force. And she goes by way of transfer as a result of the activities of Montague Smythe, other intermediaries, to the pension scheme abroad with Gibraltar. And we say that was what the parties intended by way of common design, and each took steps towards that. That is the first basis of claim. The second basis of claim at 103 lies under section 27 of FSMA.
That's the restitutionary claim. We've got that, yes we have, in the bundle.
We have. But it's actually both restitution in the sense of setting aside the agreement between each investor and Castle. Recovery of money or property transferred, so that would be the actual pension transfer, but together with additional compensation for the consequences of that transfer of money or property.
The restitution and compensation.
Yes, it's a combined remedy, my lady.
Thank
And obviously that was debated in this court last year in Adams and options, which we may come on to. But just one preliminary point, which is that if the judge is right, if the learned friend is right, Section 27 wouldn't bite in these pension transfer cases at all, because there'd be no agreement. A point that didn't occur to the two leading counsel in the case last year, or the Court of Appeal.
So the point didn't occur, or
No,
did
it's
it?
never raised. It's never been raised before, until this case that
What, never raised that there's no agreement between the...
between a pension administrator and a investor in these situations.
This is... Do you mind if I...
No, of
Thank
course
you.
not.
Just to flag this up, speaking entirely for myself, one of the things that I'm not entirely clear where you stand on, Mr. Mill, is put grounds 4 and 5 aside for a moment.
Lady.
Just look at grounds 1 to 3. Assume entirely hypothetically that you were right on grounds 1, 2 and or 3. The personal claims, everybody seems to be agreeing, would be concerned with a contract if there was a contract that met the requirements.
Yes.
The Section 27 claim, would you say must be linked because it applies to an agreement, as it were, so concerned with a contract?
Lady, yes. And I go beyond that.
Sorry, and so the overarching point is I need help on the mixed claim aspect.
Yes.
Where do you stand, ignoring the I'm going to call it the fancy stuff in grounds 4 and 5?
Melody, yes.
Just basic Gabriel approach. Where do you stand on the joint tortfeasorship and the Section 27 claims?
I can answer that quite straightforwardly. They all fall within the Article 13 test because, put it simply, and I'm borrowing language from arbitration here, what Article 13 creates is a one-stop shop for the consumer where it has an agreement of a cross-border type.
Sorry, an agreement
of a cross-border type. So if there is a cross-border issue, what Article 13 does is to create a one-stop shop for all proceedings in relation to that relationship, which has an agreement at its core, really.
I see. And you can, as it were, get there, can you, without Petrokova and Reliant Co and all the rest of it?
My learned friend and I might coalesce that Gabriel does a lot of the work,
Yes.
but in my submission, I think Reliant Co brings out more clearly what is, I think, implicit in.
But ignoring
in
Reliant
Gabriel.
Co, if you're wrong about Reliant Co, you say it's
Gabriel.
certainly the word indissociably linked is all there in Gabriel, isn't it?
We're going to, indeed, that's right, that's correct. And the test begins there. And actually, we'll look at some detail of this, but if one takes, for example, the Austrian consumer protection law, which is an issue in a couple of cases, Gabriel, I think, and Engler, which says that if an Austrian consumer gets an offer of a prize from a German marketing company, it can claim that prize even though the small print says it's not payable. That's obviously an Austrian consumer protection measure that is at the heart of some of these cases. We say, in fact, well, the Financial Services and Markets Act is directly analogous to that kind of domestic consumer public policy measure in a case like this.
But just looking at Section 27, the Section 27 claims, that could only apply to an agreement.
To an agreement,
made
yes.
by the provider. The provider here would be Castle.
Castle.
So, so that would be your answer on that. And then the
Yep.
joint tortfeasorship claims, you would say, fall within the Gabriel approach to indissociably linked
Because-
under Article 13.
Because it's pre-contractual poor conduct, yes.
Okay.
So we do say that Section 27 is an important and indeed our second basis of claim. If it's correct, it is the main basis of claim because it just unwinds, for the purposes of national UK public policy, these pension transfers. And it might be worthwhile just spelling out what we say the agreement is, just to be upfront about it. And the agreement with Castle in the beginning, through the intermediation of Montague Smythe, is to provide the service of ensuring an effective pension transfer from a UK provider to the Gibraltar provider. And that is a very specialised service, ladies. I mean, you're moving from a highly regulated relationship between the pension providers, whether the occupational pension scheme providers like the police force or police force trustees, or whether it's a life insurance company in this jurisdiction. They're highly regulated either by the pensions ombudsman, pensions regulator, or the financial conduct authority in operating those schemes. And even scarier than that, they're heavily regulated by HMRC as far as the fiscal advantages.
So you don't
pension
plead
provision.
the contract, do you? You don't, in terms, plead what the contract is in your particulars of claim?
Not in those terms,
No.
but it seemed to me to be...
You don't say that the contract was to provide services under the trust deed. You say that, or do you? You say the contract was to, and obviously you're going to look at the application form in particular, where I think Mrs. Dooley says, I agree to you executing the necessary deed of adherence.
Yes.
Is that what you say? Is that where you get
Yes.
your, to effect the transfer agreement? That's, and it's, so all the exercising of reasonable skill and care, the express obligation in the terms and conditions is to carry out reasonable skill and care in ensuring the effective pension transfer.
Indeed, and so you're moving from a very highly regulated environment in the UK to a regulated environment in Gibraltar, where there are also regulatory and fiscal rules in place. So if any of your ladyships think about moving your pensions abroad at some point, you would see online quickly there are advisors about QROPS. There are specialist providers of these things, and it's an expensive...
It's a jurisdictional issue.
Is
Rather than going into the merits. We're here looking
Yes,
at the
indeed.
jurisdictional issue.
No, I'm just making the point that it's a service. So the contract of service is the setting up of the pension transfer, and the third basis of claim at 111 is the personal claims against them in that context. And so we have pleaded quite a detailed body of rulings based basically on FCA, Financial Conduct Authority, regulations and guidance in that context. And then, of course, page 100 of the bundle, page 115, paragraph 115, allegation of breach of contract and other causes of action, breach of contract front and centre. And the particulars of breach may be of interest. It makes a point that really any competent pension company would have realised that these were not the type of people for whom this was an appropriate form of pension provision, especially subparagraph 1 of breach, dealing through an unregulated intermediary, and subparagraph 2, looking at their personal and financial circumstances. And the prayer for relief, just to complete it at pages 102 to 103, makes it clear it's statutory restitution with compensation and or else damages, breach of contract, negligence, or equitable compensation for breach of fiduciary duty. So we'll look quickly at the personal details form because it wasn't next to my list, but also in relation to what my Lady Justice Carr says. This is in the supplemental bundle.
Well, it strikes me as being a key document, isn't it?
It is.
Looking at it in contractual terms, I mean, we're not dealing here with a mere declaration of trust, are we? We're dealing with a situation where the beneficiary is also the settlor.
Well, yes.
And here, is this right? Have I got your analysis right? That the application form is effectively the offer, or perhaps the acceptance.
Yes.
But it's part of the contractual chain. It's saying, I agree to contract
Yes.
with you on the following terms and conditions, which are appendixed.
Melody, yes.
Maybe it's not the offer, maybe it's the acceptance. I don't know how you put it. But,
Indeed.
how do you put it?
I think the way we put it was that the investor makes an offer to Castle which is accepted by it.
That's how I expected you to put it. Okay.
So where do you want to take us, Mr. McNeil?
So supplemental bundle, just page 3. In case your ladyships are wondering, this actually wasn't something that Mrs. Dooley would have seen. In each of the files that I've been through, the front page of it's an internal document from Castle. It's just their own checklist of what they'd received for each file. So she wouldn't have seen this. But obviously they've received signed application forms with T's and C's and signed letters of authority. And then various documents for identification, money laundering scheme transfer paperwork, various forms that are required, I think, under domestic legislation, suitability report, self-advice letter.
These wouldn't all have been ticked at the same time because we know some of these documents come later.
I think that may be right.
So it's, as you say, important that we're not misled by this.
Yes, indeed. Just to give you a flavour of what most of the files contain, my ladies, the highest I can put it. And so, in fact, the personal, what we say is the application form, I don't think it's controversial anymore, is the document at page 4. This is Mrs. Dooley's example. And there is an expression of wishes for her husband, I think, at page 6. Details of the transferring scheme at page 5, which is the police pension scheme. And as your ladyship says, we say very important, the declaration at page 8, and signature. We confirm, first of all, the information we provide is correct. We agree to the terms and conditions set out below Appendix 2, and we agree to the fees as stated in the attached fee schedule. We hereby authorise the trustees to execute the relevant deeds to adhere the member to the scheme. So it's requesting the service of arranging a compliant transfer, a regulatory compliant transfer from the UK regime to the Gibraltar regime. We understand the fee schedule to be the document at 9. The terms and conditions are back in the core bundle at 128. Yes, 128. And you'll see they are headed as Appendix 2, which would correspond with the application form. And it states as a preamble, these terms and conditions set out the terms which the company and or the firm provides services to the clients. There is I think your ladyship will gather, there is reference to an engagement letter, which is controversial. I mean, we say there's a welcome letter, but it postdates transfer. I accept that.
Sorry, I didn't understand that. Engagement letter surely means the questionnaire and any attachments.
Indeed. So it
certainly must be the application form.
It certainly means the application form, yes, but there's no separate engagement letter, is a point I was trying to make. It does say it sets out the basis of our contract with the client, and which constitutes the agreement between the company and or the firm and or the client. So at the very least, the application form, as your ladyship says, is described by the respondent as both a contract and an agreement, which seems emphatic.
Where do I see the reference to a contract?
In the definition, my lady, at page 128 of engagement letter.
128.
128 in the core bundle.
I've got Appendix 2.
That's right.
Yes. So
it says, first of all, it says these terms and conditions set out the terms and the preamble. You've then got clause 1 definitions. And then halfway down, engagement letter means the questionnaire, which we are saying is the application form.
halfway down. Oh, yes, I've seen it now.
And any attachment, including these terms and conditions, sent to the client, which sets out the basis of our contract with the client, and which constitutes the agreement between the company and or firm to the client.
Yes, I've got it now. Thank you.
Just while we're dealing with that document, a short point under definitions. Clients means the person or persons at whose request the company and or firm is providing the services.
Good idea, yes. Yes, so the client is I think, undoubtedly the individuals in this case.
And just to be clear, you're saying the engagement letter is the application form we've been looking at
Yes.
in the supplementary bundle.
And services means the services to be provided by the company or firm as specified in the engagement letter.
That's right. I mean, there's an odd distinction between company means castle on this page. And I think we think firm is undefined in this. Firm or CTMS means castle trust. So they define themselves both as company and firm and as CTMS. And then what was held against me at first instance, even though it's not my document, it's the respondent's document, is that the definition of services is not entirely clear except by its reference back to the engagement letter. But obviously, none of the appellants are responsible for the drafting of this particular standard form.
Where are the services as specified in the engagement letter, going back to the supplementary bundle?
Well, we can't point my lady to an engagement letter which accompanies the application form on the documents we have.
I just asked if you were saying that the application form was the engagement letter, and you said yes.
What we were saying, I think it was Lady Carr says, is the engagement letter means the questionnaire and any attachments. So there's no separate engagement letter.
We don't have it in the supplementary bundle.
Yes. No, we have the application form, but not any separate attachments.
Right, okay.
Nuance point.
So when we see on page 128, services mean the services to be provided by the company and or firm as specified in the engagement letter, we don't know what those services are.
Well, the most important one, my lady, is at core 8,
Right.
which is authorising the trustees to execute the relevant deeds to adhere the members to the scheme.
Let's have a look at that then.
So back at supplemental 8.
Supplementally.
Supplementary bundle 8, yeah.
So the declaration.
The declaration is the last declaration, number 4. We hereby authorise the trustees to execute the relevant deeds to adhere the member to the scheme. That's what's needed to affect the pension transfer.
Well, this is services mean the services to be provided by the company and or firm. You're saying that implicitly it's to execute the relevant deeds.
That's the one that's spelt out, my lady. Obviously, as I say, the whole thing needs to be the service of ensuring a compliant transfer.
Has there ever been an engagement letter in the proceedings?
What we have is a welcome letter, but it's a few months later, my lady.
No. The engagement letter.
My lady,
has it ever been put before the court?
No.
There isn't one. I mean, the definition of engagement letter
Is the questionnaire
and any attachments.
So
it's not that we're missing something. There isn't one.
There isn't
over and above the questionnaire and the attachments to it.
My lady, yes, I think that's correct. I would accept that entirely.
Which is actually what seems to be envisaged by these standard terms and conditions.
And perhaps by the checklist as well. So it's envisaged that would be the basis, the request for Castle to provide services to each investor.
So that is meaningless then, reference to the engagement letter.
Not meaningless because, as Lady Justice Carr says, it does refer us back to the application form at least.
Yes, but in the terms that it is expressed, there is
the
no
services,
engagement
yes.
letter. So that is a meaningless phrase.
My lady, except that if one goes back up the definitions for engagement letter, it says it means the questionnaire.
So it's surplus to requirements then. All right.
It's
Okay.
yeah, it's not the happiest of drafting,
No.
but obviously we're doing the best with what Castle have provided to each investor.
Yeah.
And of course, remember that as a reciprocal undertaking, the declaration requires each investor to pay the fees that we've talked about in the fee schedule, so it's clearly reciprocal in that sense. And you'll see then there are a number of provisions you might expect to see in a contract of services from a financial services professional. There's an express duty of confidentiality in clause 2. There is again a pretty unhelpful clause 3 headed provision of service. Which is also not easy to read. I mean, the one point you might take from it is that it includes, interestingly, reference to the UK Bribery Act. So obviously, Castle was very aware in drafting this that it might be caught by the UK Bribery Act in its activities. And then clause 4, headed due diligence, is really about money laundering. The company and or firm is required to operate anti-money laundering and other checks and procedures in respect of all aspects of the provision of the services. And then it goes on to say what it can ask for verification of. And that imposes obviously obligations on the client to comply with the money laundering checks. Ladies, this was delegated to Montague Smythe by Castle. So the very important process of complying with money laundering requirements, both in the UK, it would seem, and the UK end was delegated to Montague Smythe.
As my lady would say, what for present purposes?
It's relevant just to my case on invitation and inducement, obviously. That this is a very active intermediary in the UK. And it's really clause 6 that sets out the obligations on the investors to pay the fees and allows them to deduct fees from the funds of the trust if necessary. But it envisages an ordinary kind of invoice basis of fees. But we say that is a proper basis in the relationship between the parties of each investor's obligation to pay fees to Castle, not the trust deed.
Well, the application form.
These T's and
carried
C's.
the obligation, didn't it?
Indeed, yes, and this spells out in more detail what that involves, including provision of invoices, rights to claim interest on overdue invoices, a very important right to deduct fees from the trust fund. So all the detailed rights that the Castle might want to exercise are spelt out in these T's and C's.
Well, that could be an important point. Can you just show me where the, I think, and I went online, the digital copies are no clearer than the photocopies we've got here. Where is the right to deduct fees from the trust?
Yes, so second paragraph of that clause 6. So you'll see the first paragraph does refer back to the engagement letter for the remuneration. The company and or firm reserve the right to deduct such fees and expenses from any of the client's funds of the trust. But in addition...
But doesn't that go to the heart of one of your points, which is that here there clearly were mutually coexistent relationships?
Indeed. And
the trust relationship and the contractual relationship.
Indeed. And all I need to do to persuade you on ground one, my lady, is to say that, well, the judge has said the relationship is exclusively one of trust and that all the rights and obligations from the parties is exclusively one of trust. All I need to do is have the better of the argument that, at the very least, the relationship between each appellant and Castle was a mixture of a contract for services and the resulting trust deed. We're not saying the relationship was exclusively contractual, we're just saying that the first in time, and necessary preliminary part of the relationship was an agreement for the provision of services to set up a compliant pension transfer. And in terms of how...
Not that it matters, but I mean, have their invoice, fees and disbursement invoices were raised?
Well, yes, you can see the initial one, my lady, at supplemental page 10, I think it is. Page 11, I was close. Page 11 of supplemental. So this is Mrs. Dooley's initial statement of account. And you can see that it references certainly various deductions and fees. So there's the transfer from Michelle, the pension in, £120,000 odd. Castle's annual and setup fees, that's two amounts of 1%, at 2,409. The very next thing is a £2,000 fee to Montague Smythe. There are then various other miscellaneous charges and IFA fees at the bottom of 750. But obviously, the second entry there is Castle Trust's own 1% for setup and 1% for the first year.
And that 1% setup is in accordance with
The document on the previous page, page 9.
minus 995.
I think it's minute.
995 is minimum, yes.
Sorry,
So,
forgive me. Yes, thank you.
so she's about £120,000.
Yes.
She's at the higher end of these particular
Yes,
pension pots.
thank you.
But you can imagine it's more expensive than having the police pension scheme trustees administering it.
If there was no contract, what entitlement would Castle have to invoice?
My lady, I would say none.
No, it's an open question.
None. None. I mean, you would need to have a trust is a trust, as you say. There's
nothing in the deeds or the rules.
There is one thing we can go to it. The judge rather mangled this in his judgment, and we can go to in detail. It's clauses 8 and 12 will be relevant, but I will take you to them. But we say that they don't work, and they certainly don't.
Do they provide for 1%?
No.
Do they provide for minimum?
No.
Do they provide for bank payment charges?
No. No interest.
Do they provide for interest?
Nothing along those lines. No. There's reference to a schedule, I think.
In the trust deed?
In the trust deed.
And that schedule exists?
Well, the trust deed, of course, dates back to 2009. Yes. So,
yes.
Again, it would be.
Okay.
So,
but as a matter of fact, Mrs. Dooley was charged in accordance with this schedule.
Indeed. I think all the claimants, I've been through all the files, have been charged on the same basis. It's really worth taking you then to the trustee, because I think it is probably important then as a point. So, it starts...
Sorry, I took you off your course. You were
but
going through this.
It might be worth...
You finish the terms and conditions.
Okay, I think I was nearly done with the terms and conditions, but I will carry on a little bit further. So obviously, clause
8.
Clause 8 we were looking at, and the only other key points I think on that are there is the express undertaking in clause 8 at 130. The company and/or firm will provide the services with reasonable care and skill, and acknowledge the company and/or firm will be liable for any loss or damage caused by its negligence, breach of contract, fraud, and or willful default, with a carve-out. There are then various obligations imposed upon the clients in clause 9. and a jurisdiction clause at the end.
What does the termination clause say?
Oh gosh, it's not very clear, is it?
No. 1 month's notice.
Yes.
Company can terminate services upon 1 month's notice.
And then it has a checklist of qualifying events such as insolvency.
And immediate termination upon any of the termination.
Yes, that's right. The classic sort of
Yeah.
setup. So any breach by the client would be sufficient, it seems. Or failure to supply money laundering information, etc. Yeah. But it's certainly the type of document you'd expect a professional financial services firm in any jurisdiction to want to have as a basis for its dealings with its clients. I mean, the absence of it from the relationship would be very surprising.
So you're going to take us to the trustee?
Yes, I mean, just finding on that page that there's a jurisdiction clause that really is a governing law clause at the bottom of 183. So the trust deed is in supplemental page 12. And the judge deals with this in the judgment at paragraph 69.3. I don't know, but we say he somewhat mangles the analysis. That's at page 64 of Core. And this probably is an important part of the judgment to look at.
So page?
Page 64 of Core is probably, I mean, this is really the core of this ground one point. So he says at 68 is, nevertheless, in my judgment, it's clear from the evidence before the court that Carr's obligations to claimants rested fundamentally upon the trusteeship of the QROPS, rather than a separate contract for provision of financial administration services. There is no plausible evidential basis for saying a contract was concluded for the supply of services outside those which were identified by the deeds and the rules, which were incorporated by them. His first point is that the T's and C's don't really spell out the services. Then he rejects the later welcome letter. But really, it's at 3, he says, the overall service mentioned in the welcome letter can only have been that identified in the deed and the rules. In the case of Mrs. Dooley, the instrument of adherence to these documents was executed on 23rd September 2014, which was some 3 weeks after she gave Castle authority for that step to be taken. There was no need for, and there is no evidence of any prior separate contract for services outside the deed and the rules. And then it describes the beginning of it in the rules. He then says, Clause 8.2 provided for costs, charges and expenses incurred in establishing, administering or managing the plan, apparently undefined to be paid out of the trust fund. Well, if your ladyships turn to Clause 8.2 in the supplemental bundle, it's at page 17. The trustee shall pay all costs, charges and expenses incurred in connection with the establishment, administration and management of the plan out of the fund. We say that's just a normal provision that the expenses of the trust get paid out of the fund. So that doesn't impose any obligation on anybody in that context. And then clause 12 provided for Castle's professional fees for time spent in relation to the trust hereof or the administration of the plan. The clause referred to Castle's entitlement to charge fees for its trustee services, as shall from time to time be published.
I'm very sorry, Mr. McNeill. I don't know where you're referring to.
So I've gone back to the judgment, my lady. Sorry.
Right, okay, back to the judgment. Paragraph?
So it's back on page 64, paragraph 69.3.
Right.
We just looked at 8.2.
And you're now reading that clause 12.
I'm now reading the judge's summary.
Referring us to clause 12.
I'm referring you to the judge's summary of clause 12.
Thank you.
Clause 12 provided for counsels professional fees for the time spent in relation to the trust hereof or to the administration of the plan. The clause referred to counsel's entitlement to charge fees for its trustee services, as shall from time to time be published as its normal scale of charges. This can only be a reference to the fee schedule to which the member expressed agreement by the declaration on the personal details form. In the evidence on the application, there was a fee schedule for the Equus and Metro schemes published by Castle in October 2015. So he sort of linked it, he's linked the language there to a fee schedule that comes obviously much later. If your ladyship can turn back to the core, pages 18 and 19 is clause 12.
Yeah, back to
Supplementary.
Sorry, back to the supplemental bundle, I do apologise. Page 18. Clause 12 headed trustees' entitlements. And it says, clause 12.1 he appears misunderstood. It says, any trustee for the time being hereof being an accountant, advocate, solicitor, actuary, or other person engaged in any professional business shall be entitled to charge to be paid all usual professional or other charge for business done or services rendered or time spent by him or his firm in relation to the trust hereof or to the administration of the plan, including acts which a trustee who was not a professional person could have done personally. So Castle, of course, is a company, and this refers to individual professionals who are also trustees. So we don't see how that quite answers the point. The highest it could be put is what is separately 12.2, although the judge runs them together. Any trustee which is a company shall be entitled to such fees or remuneration for services as trustee as shall from time to time be published as its normal scale of charges. So again, that looks like a general right to charge the general fund rather than particular sub-funds of particular pensioners.
What you're saying, are you, that these clauses, that the fee schedule and the application form, as it were, overtakes the wrong thing, but are separate and distinct to and additional to is probably the best way of putting it. Additional to these general obligations.
Yes, I mean, those we say are sort of overarching rights of trustees to deduct usual expenses and fees. But what is being charged for is a service of initially setting up and continuing to operate a compliant pension scheme in Gibraltar. And that is only spelt out clearly in the declaration, in the application form, and in the terms and conditions. The ladyship may have seen it came as a surprise to us in the application to challenge jurisdiction that was made, that the only documents exhibited to the application were the trust deed and rules. It was ourselves who had to put in the terms and conditions in response.
Well, the onus is on you, so I don't know that's a good point, Mr. McNeill. Can we actually get on with what we need to get on with rather than the surprise expressed?
Well, we were surprised. I will get on with the next thing. So we've looked at the terms and conditions. We should just look for completeness at the welcome letter.
Yes, please.
There's nothing in the rules we need to look at.
Lady, we don't think so. I mean,
Okay, that's fine.
the judge only refers to the rules in the most general terms. So just finally, in the supplemental bundle at page 10, is the welcome letter to Mrs. Dooley. And this is relevant to a couple of grounds, so I'll just take you through it. But we say it supports our case, that there's a good arguable case that Castle is both acting as administrator and as a trustee. So we would like to welcome you as a member of the Equus Retirement Annuity Trust Scheme, administered by Castle Trust and Management Services Limited, who also provide ongoing fiduciary duties as trustees to the scheme. We think that sets it out pretty clearly, and that...
So you mean also?
Also. And that would be normal in this jurisdiction. Normally, with two companies in the same group, one would operate and administer the scheme, and one would be the trustee. In this case, it's just one company, but they themselves have explicitly drawn a distinction between administering the scheme and acting as trustee. And then it goes on under the scheme details, penultimate paragraph. As part of the overall service, you will on each anniversary of your joining the scheme receive an annual statement detailing the current valuation. This will be provided to you by Castle Trust and Management Services Limited as your trustee, so making it clear in what capacity it does so.
Well, Mr. Hart and the judge relied upon that phrase as being, as your trustee, simply a service being provided as trustee, not administrator. But you say he overlooks the references elsewhere to administration.
Indeed. And in fact, the very last paragraph as well is important, and this is relevant to ground 2 in particular. Should you have any questions with regard to the scheme, either now or in the future, please do not hesitate to contact your introducer, Montague Smythe in the first instance, or Castle Trust and Management Services Limited as your trustee and scheme administrator. And you'll see at the bottom it's carbon copied, CC'd to Montague Smythe. So a continuing role seen for the UK-based intermediary in the welcome letter. And the last preliminary document arises from the pre-action correspondence. And the judge didn't think this was helpful, but we continue to say it is helpful. It's in the supplemental bundle starting at page 40. I mean, the first 2 pages we don't need to look at, but it's saying that the claim is doomed because of the first instance judgment in Adams and Carey, which is reversed by this court later. It then introduces Montague Smythe on page 43. Second paragraph there says, our client cannot respond to allegations against Montague Smythe. Insofar as CTMS Limited is aware, at all material times, Montague Smythe is an aggregator and distributor of financial services products and operated through a network of independent financial advisors. And then the next paragraph, the nature and extent of our client's involvement with Montague Smythe is set out below.
Sorry, it's my fault, I'm behind you. What page are you on?
Page 43 of the supplemental bundle. Just introducing Montague Smythe in the pre-action process. And just in terms of what was done by way of service by Castle, pages 44 and 45 I think are helpful. We don't need to go through each bit of it, but basically it describes a process by which each individual filled in forms and the steps taken by Castle to arrange a compliant transfer.
Is this under facts?
Under facts, my lady, yes. Yeah. So it says back in 2009 they established the trust. In March 2014, the claimant received a transfer out request pack. On the 26th of August 2014, the claimant signed a declaration confirming that her pension must be transferred to another registered scheme to be confirmed by a declaration made by the receiving scheme. I mean, that's important because, of course, no UK pension provider will release pension monies to anybody other than generally a UK other authorised pension provider. to preserve the fiscal benefits. Or in these circumstances where there's a qualified recognised overseas scheme, where it's satisfied it's releasing it to somebody else who will treat it in the same way as HMRC require. So it's quite important that you have a willing recipient of pension funds that's properly regulated and subject to tax oversight as well in that jurisdiction, as well as authorised by HMRC. So they refer to what's called the self-advice letter on the 1st of September. But in terms of the proper legal steps, page 45, on about the 2nd of September 2014, the claimant completed and signed the Equus Retirement Annuity Trust Scheme application form, together with an authority form authorising CTMS Limited to approach her pensions provider, Michelle. Then there's a letter about agreeing fees for Montague Smythe. And then on the 23rd of September 2014, CTMS Limited wrote to Michelle, i.e. the police pension trustees, requesting the transfer of the claimant's pensions into the scheme and providing them with the necessary bank details and a declaration made by CTMS as trustee of the scheme, being the receiving scheme, and enclosing a QROPS letter of acceptance from HMRC. So without those steps, somebody with appropriate authorisation in Gibraltar, as well as effectively an acceptance by HMRC that it operated a qualifying recognised overseas pension scheme, there could have been no pension transfer. And those are essential steps for the money to go offshore. And we say that illustrates the services being provided at the initial stage by Castle. And then lastly on this letter, pages 49 and 50, we get a bit more about the relationship with Montague Smythe. About 2/3 of the way down. As part of its ordinary business-to-business dealings, CTMS Limited enters into referral arrangements with pension investment managers and providers for the provision of trustee and administration services. Prior to the provision of services to the claimant, again, an acceptance of the services being provided to the claimant, CTMS was approached by Montague Smythe. Montague Smythe informed CTMS they were looking for a provider of pension, trustee and administration services for a number of pension clients. CTMS Limited understood that they were, at the time, one of a number of professional trustees and administrators approached by Montague Smythe to provide these services. In due course, Montague Smythe selected CTMS Limited to provide these services, and terms were agreed. So that's the document I complain about not having sight of, which is the arrangement between Castle as product provider and Montague Smythe as intermediary. But we do know a bit more from the next paragraph. CTMS Limited understood that Montague Smythe were promoting inter alia the Aspero investments through the network of independent financial advisors, of whom Abrams Ashton was presumably one. It was agreed between CTMS Limited and Montague Smythe that the latter, that's Montague Smythe, would prepare a Know Your Client and due diligence pack for each of the clients they referred to in order to streamline and speed up the referral process. The outsourcing of the collection of this documentation is the only work that was carried out by Montague Smythe on CTMS's behalf. For this work and for the other work as detailed above, Montague Smythe received a fee of £2,000, which the claimant was perfectly aware of. It denies any sharing the spoils. Now, Know Your Client and due diligence means money laundering checks. That is money laundering checks. KYC is money laundering. So when I say that there is an admission that they at least delegated the money laundering checks to Montague Smythe, that is from the horse's mouth. So that will go. So there are aspects of that. Bits of it go to ground one. Obviously, the acknowledgement that there is provision of services, and Castle's quite careful differentiation of trustee and administration services. But bits of it go to ground 2, which is the relationship with Montague Smythe. I intend now to move on to the heart of it, which really is the instruments and the CJEU decisions. And we know there are 6 separate judgments of CJEU in the bundle. We might need to look at each of them very briefly at least. We say you look at all 6. The first 3 are on the convention, and of course, as the convention is modified, it applies between the UK and Gibraltar. The next 3 are on the regulation or recast regulation. The judge looked at the first 4, which isn't entirely consistent. It should either be the first 3 or all 6 in our submission.
Just my ignorance, the recast regulation doesn't apply because it's never been enforced so far as the UK and Gibraltar are concerned.
No, we've never changed, I think, the regime. So the point is that...
It came in 2012.
Yes.
It doesn't apply between the UK and Gibraltar.
That's my understanding too. Section 39 of the Civil Jurisdiction Judgment Act is still sitting there.
Yes.
And the Ordering Council is still sitting there, which is brings in the convention. So neither the regulation nor the recast regulation ever applied to UK-Gibraltar relations. So because they're not both member states. So Gibraltar is British.
So the Article 13.3 only is applicable because of the Gibraltar order.
Only.
Yeah.
Yes. So.
But we take that just sort of loosely as meaning right. Well, Article 33 is the applicable one for our purposes.
Article
13.
Yes, it is. That's correct. Yes, my lady. Yes. So it's still on the statute book, in the same way that between
what's still on the statute book.
But both the Section 39, which is the source of the order, and the Ordering Council are still legislation in this jurisdiction. I think they are still the governing measures.
Yeah.
Because they're between Gibraltar being a British Crown colony, but as part of the EU, this was brought in as a measure that applied an equivalent regime to them. In the same way that the same modified convention applies between different parts of the UK.
Yes.
That's the approach taken.
But the main point is the recast regulation, the new wording, 17.1c, does not apply.
Does not apply.
No.
And I haven't said it does.
No.
The wording change is in relation to one aspect of it, I will say, and I'll go through the bits where there is continuity between the instruments. What we say is that while some of the language and detail of the various successor texts, and in fact, in some ways there are 4 texts. There's the convention itself, then the regulation, then the recast regulation, and now we even have a domestic measure trying to replicate these measures in sections 15A to 15E of the Civil Jurisdiction and Judgments Act, borrowing from the regulation. They're all successor instruments. But we say that there is continuity. We say that the consumer contract test is a distinct ground for jurisdiction, and it aligns in the convention with the insurance contract and employment contract tests as a grouping of 3 status-based tests which reflect the inequality of bargaining power or arms between those parties and those relationships. And we say that there's a distinct public policy underlying the consumer contract basis.
Which is what? To protect the consumer.
Protect the weaker party. Well, there are 2 aspects to it, really. First of all, it is to ensure that consumers can always sue in their home jurisdiction. Because as the weaker party in the relationship, they should be protected by rules of jurisdiction more favourable than the general rules. But secondly, the language of the Convention especially makes it clear that it's a wider basis of jurisdiction than, for example, special jurisdiction in relation to contract and tort generally, because it creates a one-stop shop whereby all difficulties that arise, all the issues that arise between the consumer and the business will be ventilated in one forum. So when we look at
whereby all difficulties,
all issues that arise between the consumer and the business are ventilated in the same forum. What I'm describing as the one-stop shop approach, which is not quite what happens under special jurisdiction, for example, for contracts in general under Article 5.1. If you establish special jurisdiction under Article 5.1, you only get Article 5.1 jurisdiction for the things that are matters in relation to contract. And the best place to take that from, of course, is the Convention itself. So in the authorities bundle, I mean, the European Court is very careful when it goes through it to specify that the relevant bits are within Title II of the Convention, and there are a number of separate sections. So Section 1...
Which page are you looking at?
Page 6 of the authorities bundle. So we're looking at jurisdiction, Title II, and there are a number of sections. So the general provisions, which includes obviously the general rule, the default rule of the Convention, domicile of the defendant in Article 2. And then Section 2 is headed special jurisdiction. And it says a person domiciled in a contracting state may, in another contracting state, be sued. And then it says 1, in matters relating to a contract. And we don't need to go through the rest of the test, I think, but it's the language of matters relating to a contract, which is important. And then also relevant is, by way of background, is Article 5.3 in matters relating to tort, delict, or quasi-delict. And that gives a harmful event rule. Where the judge thought we landed was Article 5.6. As settlor, trustee, or beneficiary of a trust, created by the operation of a statute, or by a written instrument, or created orally and evidenced in writing in the courts of the contracting state in which the trust is domiciled. So he thought we landed in Article 5.6. Over the page in 8, you'll see there's Section 3 is jurisdictional and insurance. And just by way of continuity, that refers to in matters relating to insurance. But going on to Section 4, which is our section.
So where's the employment section?
Yeah, I think it may have been left out of this copy, but I think it may have been left out of this one, which is. I
don't remember seeing the employment section in Title II.
No.
So I think it's just insurance and consumers.
Yes, in this version.
It
may not. It may. But the point of contrast I'm trying to draw is between the Article 5.1.
I understand that, but you just made submissions by reference to
employment contracts.
Yeah.
We certainly have the.
I hesitate to interrupt, but I can assist my learned friend. My understanding is there is no provision in the convention in relation to employment matters.
That's mine
It's a
too.
major
Oh, yes.
introduction to the regulation, and obviously therefore goes through to the recast
Yes,
regulation.
that's
But
what
there
I
wasn't
remember.
one in the.
No, that's
No, that's correct. I
Yeah,
think that's right.
thank you.
Yes. It was just insurance and consumers.
Yeah.
And of course, under our new rules, it's just employees and consumers. The insurance has not been carried forward in the domestic version. Not seen as being as unequal anymore. But the contrast is I'm wishing to point between Article 5(1) and the initial wording of Article 13, page 9, jurisdiction over consumer contracts. It says in proceedings concerning a contract, and we say that's the one-stop shop language. So that is the basis for saying that really, if there's a contract and there are proceedings involving that contract, as we'll see in the EU jurisprudence, all those causes of action come in.
You know, if 4 lines down, without prejudice to the provisions of point 5 of Articles 4 and 5. That doesn't make any sense to me. What am I missing?
Yes, I mean, there's a number of these without prejudices that have had me scratching my head in the past. I mean,
It can't be. It's certainly, Article 4 hasn't got a point 5, and Article 5.5 is irrelevant and inconsistent with what comes at the bottom of this article. If that makes any sense. All right,
Yes.
nobody can help me.
no.
My lady, I think I possibly can. My understanding is that it disapplies the rules in relation to, or makes clear that the rules in relation to branch and establishment that are Article 5.5 Article 5 rules don't apply here because there's specific language in terms of
Exactly,
tethering
bottom.
and connection
Yeah.
to the jurisdiction of the consumer.
And then
that's
four.
the specific invitation and advertising requirements. So it's just making clear that there's no inconsistency between the burden that you have to show that there's a sufficient connection through specific advertising and invitation. But there's no contradiction between that and the separate rules on branch and establishment, the special jurisdictional rules for under Article 5 for branch and establishment.
Right, I get that. The reference to Article 4 is a mystery.
It looks wrong, doesn't it?
Yes, my lady.
It looks wrong.
Yeah.
I mean, the instrument was, I think, consolidated on a number of occasions following the various accessions.
Yeah, I'm just going to ask if it's possible for someone to close the window, please, because we're getting a lot of noise distraction, quite a lot, quite apart from it being quite cool.
Yeah. Yeah. Thanks very much.
I wonder if you could try the other one too. It looks to be open from the top. It's a bit better, but thank you. Thanks very much. Sorry, Mr. McNeil.
That's all right. Yes, so Article 13, we do say, and we'll see that that has been developed in the case law. And Article 14 then gives the right of people to bring the claim in the home jurisdiction. And obviously it's paragraphs, subparagraph 13 of 3 that we put our basis on. Any of the contract for the supply of goods or a contract for the supply of services. And A, in the state of the consumer's domicile, the conclusion of the contract was preceded by a specific invitation addressed to him or by advertising. That's really grounds 2 and 3. And the consumer took in that state the steps necessary for the conclusion of the contract. And it was conceded in this common ground that each appellant is a consumer, and that each appellant took those steps in Article 13.3b in the UK, necessary for the conclusion of the contract, and that effectively the agreement to sign away one's UK-based pension rights.
So it's just invitation or advertising that we're concerned with there.
Exactly. Once one moves on from the ground 1 point about whether there was a contract at all.
Yes.
Yes. So it's literally Article 13.3a is the core of it. And as I've tried to establish, without going as far as saying that Montague Smythe was an establishment of Castle in the UK, we say it was an intermediary entrusted with issuing specific invitations to UK-based investors to look to transfer their pensions to QROPS with Castle. And we think that's the only common sense reading of the evidence.
Sorry, does it have to be Montague Smythe on behalf of Castle? I mean, you say joint tortfeasorship or principal agent, but does it have, looking at the wording of 13.3a, does it have to be a specific invitation addressed to him by the defendant?
Well, I think it'd be very unwise to introduce sort of English common law concepts of agency into this and saying that that would be read into it. That would be very contrary to European approach to these things.
That's what you've done in the skeleton, and that's what you did below. You say either joint tortfeasorship or as principal agent. Do you need that? Would it be enough for Montague Smythe acting for its own completely independently to have it issued a specific invitation? Would that satisfy 3A?
On the language
over Castle.
On the language, maybe yes.
Right. So it's a specific invitation by anybody.
I mean that's where on the natural language, I accept it needs to be looked at in context, and of course we look at it in how what that means in practice.
Is there no law on this on specific invitation?
There's a little bit of guidance, and let me take you to the best guidance. Probably is right at the back of the author.
Don't take you out. I just want to understand your case. So you say, the matter of construction, it can be a specific invitation from anybody, provided it's in the state of the domicile, of the consumer's domicile. That's enough. Alternatively, if it needs to be a specific invitation on behalf of the defendant, then you say there's enough here for Montague Smythe to be agent of or joint tortfeasor with Castle.
I mean, even the language we say that the Castle itself is happy to use in all its documents of introducer is a sufficient relationship for these purposes. So it's described as introducer.
Or middleman.
It's paid as introducer. Yes, it's paid as introducer.
Okay.
It carries out tasks.
I think it's a slightly surprising submission to say that it could be a specific invitation from anybody.
No, Mother, I was saying on the language, you might say on a natural reading of the language, it's that wide.
Right.
But I haven't put it forward in those terms.
So what is your case?
My case is that it's sufficient that invitations by Montague Smythe, in this case, invitations made under an arrangement with Castle to promote and introduce its QROPS, was a sufficient invitation or
Yes, sufficient invitation.
a sufficient and specific invitation to these individual appellants. I say you later pointed out in the particular claim earlier on when I looked at it, that we said that we understand each of these investors has had it promoted or introduced to them by Montague Smythe on behalf of Castle. So we say that's sufficient. In the evidence that we have is that this is far more direct and close than internet advertising. So advertising is a much more general basis for jurisdiction. we say we clearly get home under 3A. I mean, the concession that the consumer took the steps necessary in the jurisdiction under 3B rather makes the point. None of these consumers took the steps in 3B without it being initiated by somebody who introduced the concept of Castle as a provider or its QROPS as a product to them.
Is it possible to say that it's necessary for the appellants to establish one or the other? Because, of course, if they contacted Montague Smythe as a result of seeing the web page, which may or may not be advertisement, then they haven't been specifically invited. They have been doing the invitation to an intermediary to intercede on their behalf.
Yes, we're not aware of any advertising that Castle authored that referenced any particular intermediaries. But I see your ladyship's point. I mean,
it's not a point. It's a genuine question. That the framing of Article 3A is that was preceded by a specific invitation addressed to him or by advertising. And there is an issue as to whether or not the website is advertising in this particular case.
well, yes.
And so if Mrs. Dooley saw on the web this particular page that says that Castle is fantastic and we're authorised by HMRC and all the rest of it, and thought, I'll get in touch. And then as a result of getting in touch, she's contacted. Do you say that's a specific invitation addressed to her?
Well, it would be, yes.
Even though she's initiated the contact?
Well, yes, because obviously what we regulate and what we are concerned about for both regulatory and jurisdictional purposes are actions by defendants or their agents.
Well, why say specific invitation to her, addressed to him?
Well, I mean, this it has to be accepted. This is a consumer protection measure, but in this version, it does set the bar quite high for the consumer to say that I was, invited. But
that's why I'm asking, because you've made the point that this is, a policy that we've got to look at it through the eyes of public policy and protecting the weak, and yet there is this requirement provided by Article 13.3a, which is quite specific. And we know how advertising has been interpreted.
Yes, I mean, it hasn't been said by any of the claimants that they saw the advertising.
No.
That was mainly by way of background, which establishes that
so you're
Castle
fully
was,
behind the specific invitation point.
Indeed, ground two is first and foremost of my points.
Are you actually withdrawing ground 3?
Melody, I think ground 3 is probably difficult to make out for the connection point, I think, because I don't actually have evidence on that. So I rely upon the website by way of background. But what we say in this case is, in fact, as the particular claims say, in the normal way with these pensions cases, it is cold calling, it's social media advertisements, it's all the kind of chatter under the water that I don't see.
But it's got to be addressed to him. So cold calling often starts dear resident or dear fund holder. I mean,
but that would have to be sufficient. That would have somebody who's targeting consumers.
As long as they're targeted as a consumer, that's your point.
That's my point. That's exactly what the obvious purposive construction of Article 13 must be.
So in other words, to the occupier of such and such address, that is sufficient.
Indeed, nowadays it would probably be cold calling on mobile phones, so it would be.
Well, that would certainly be right.
It's very much what we say is that this is our pleading case.
Yeah, I mean, if it would assist, I just I have no difficulty with accepting that a mail shot or mail order
Would be
because
sufficient.
that's exactly what the
That's very helpful.
say.
Thank you.
I mean, the provenance of this particular version is sort of more sort of mail order catalogues going across the German-Austrian border back in the 70s.
But you've got the concession now. So
That's helpful.
yes, thank you.
And I think it's in Malone and Friends' own skeleton, but it's in the Giuliano Lagarde report at the back of the tab. So in the authorities bundle, the report starts at 435.
Thank you.
But Malone and Friend is almost quoting pages 457 and 458. So right at the bottom of 457. And this is technically on Rome 1, I think, rather than Brussels Convention, but it's incorporated by reference as guidance for the Convention. The first indent relates to situations where the trader has taken steps to market its goods or services in the country where the consumer resides. It is intended to cover inter alia mail order and doorstep selling. Thus, the trader may have done certain acts such as advertising in the press or on the radio or television, or in the cinema, or by catalogues aimed specifically at that country. Or he must have made business proposals individually through middlemen or by canvassing.
Well, that's the middleman analogy with
Yes.
Smile.
That's what we say, middleman at the very least, which is helpfully not linked to any particular jurisdiction's concept of agency. So I think if we start with the European jurisprudence, and I think we can take Cal Baylis quite quickly. That's at tab 9, starting at page 95.
I don't know about my ladies, but I haven't got tabs.
No, okay, I'll stick with
Just
page 95.
bear with us occasionally, Mr. McNeil. I think we are slow in catching up. Page 95.
Page 95.
Well, I haven't got any tabs and I've got no sidelining, so I don't know if you've got something different. Mr. McNeil, my lady makes the point that there's no sidelining.
Oh, yes. That's an oversight on my part.
So where do you want to take us?
So just in Cal Baylis, so I'm just...
Is it just that derogations to be read?
Yes, so Cal Baylis is really, and the first point, of course, is that Cal Baylis is a Article 5 case only. So obviously it makes the point that contract is an independent concept, and derogations are to be interpreted strictly.
And the paragraph reference to that is?
19. I think the first case really directly on Article 13 is Gabriel. And
Page?
page 108.
Yep.
And this is one of these cases on the Austrian consumer protection law, which we say is at the very least analogous to sort of our own domestic consumer protection measures, including the Financial Services and Markets Act. Financial Services and Markets Act is to protect your pension and your investments. the Austrian law goes further. It gives you a prize if it's been promised. And it's important to note, I mean, I don't want to delve into the facts too much, but what the Austrian law does, it says, well, in the big type, it says you get a prize. And then in the small print, it says, no, you don't. And the Austrian law just overrides the small print.
So what principle are you seeking to draw from this for the purposes of our case, rather than the prize draw?
The purpose of this case, it's a consumer protection measure, so it falls within Article 13, my lady, even though you're not enforcing the contract. If you're enforcing the contract, you'd get nothing. What you have is a matter in relation to a contract in which the domestic Austrian law, in the jurisdiction of the consumer, overrides the German
It's the
companies.
breadth of the words in proceedings
Exactly.
concerning a contract.
It's a one-stop shop point, which is that statutory measures affecting what the contract does, including overriding its express wording, are clearly the subject matter of the jurisdiction test in Article 13. So it's quite an important point, really, that FSMA is directly analogous to these types of measures that the Austrians have. And so it's important that in Gabriel, the recipient did actually make a contract, because there was a requirement for a contract being made in Article 13. That's conceded here. And I don't tend to take you through every part of it, but your ladyships might, if you're looking at this in more detail, find the Advocate General's opinion also useful.
Well, we're interested to know what your submissions are, Mr. Macur, rather than having a bedtime read for our own edification. So where do you take us to?
I will take you to Advocate General Francis Jacobs.
Right.
Quickly at page 117.
Right.
A31.
Yeah.
Just for a point the judge found important, I think it's better put by the Advocate General. If I may say so. Article 13.3 requires first the proceedings shall concern a contract for the supply of goods or services. Secondly, then quoting the specific limitation point, and thirdly, the consumer took in that state the steps necessary for the conclusion of the contract. The purpose of the second and third cumulative conditions is to ensure a sufficiently strong connection between the contract and the country of domicile of the consumer. So what he's saying is, of course, that the conditions themselves, in particular condition 2 and 3, specific invitation, and taking the steps in the consumer's own domicile, themselves are a sufficiently strong connection. You don't need to look for something additional by way of sufficiently strong connection.
And how did the court regard that submission?
The court, it's in the judgment. I think he's on the judge. Russen would have to look for something a bit more in addition to
Well, do you want to take us to Gabriel first of all? How did the court adopt or distinguish the advocate's submission in Gabriel?
Gabriel was largely adopted, my lady.
Right.
It's just that on that point,
I'm really sorry, I'm struggling to identify where in which paragraphs in Gabriel do you rely upon? Judgment.
Sorry, it was page. So it's.
Judgment starts at page 124. And where do we get the one-stop shop? Man stuff.
Oh, so in Gabriel, sorry.
Yes, please. Sorry.
Take you back. So, if it stays in the Advocate General, my lady, so you'll see.
No, in the judgment. We see what you've just taken us to a very pertinent submission, and the questions that we've all asked really go to where in the judgment.
In the judgment.
Gabriel, not in.
Oh, I see, my lady.
Not in Dooley. The judgment in Gabriel.
Unhelpful.
Do they deal with that submission?
By the Advocate General.
Yes, how does the court deal with the Advocate General's submission on the point of Article 13.3? In order that we can see what principle you extract from this.
Paragraph 39 ensures adequate
So
protection.
in fact, so if to finish off the point,
Paragraph 41, I think adopts the Advocate
so yes, it's really so Advocate General paragraph 31, page 118,
Yeah.
who then refers to the Slosher report, page 158, and then that is adopted at paragraph 41 of the judgment.
41.
41,
Thank
page
you.
130.
Right, the 44 addressed directly, specific invitation by means of catalogues, commercial offers made to the consumer in person by an agent or vehicle salesman.
Milady, yes. And also helpful in this judgment is, because obviously we're looking for the independent concept of contract, and I think we get that in paragraph 49, where the European Court talks about a concordance of intention between the parties, gave rise to reciprocal and interdependent obligations within the framework of the contract. So,
And I think you can actually read on from paragraph 44.
yes, indeed, with regard to the second of those conditions, the expression steps necessary for the conclusion of a contract refers to any document written or any other step taken whatever by the consumer in the state in which he is domiciled, in which he expresses his wish to take up the invitation made by the professional lady. That's right, that would be the application form in blunt terms.
And then 46 ends it.
Yes, all those conditions are satisfied in the case of the Austrian consumer. And then, as this is probably the most important case, Gabriel, in many ways, in terms of this case. So we do rely upon all of 44 to 49. And then, as the lady Justice Carr has already suggested, this is the beginnings also of the indissociable relationship test, which begins at paragraphs 54 and especially to 56. I invite you, ladyships, to read 54 and 55.
Yeah, well, when the time comes, you'll have to help me at least on the basis for your submission that the Section 27 and joint tortfeasorship claims are indissociable.
Milady, yes.
As they're identified in Gabriel, linked so closely to that contract.
Yes, I mean,
Yeah.
I've sort of trailed it with the
I
consumer protection point.
understand. You'll get there when you get
Yes.
there.
So 56 says, is the beginnings really of the one-stop shop point. So, and this really begins to answer your point, my lady, I hope. An interpretation of Article 13, first paragraph of the Brussels Convention, which would have the result that certain claims under the contract concluded by a consumer fall within the jurisdiction rules of Articles 13 to 15 of that convention, whereas other actions that are linked so closely to that contract as to be indissociable are subject to other rules, cannot be accepted. So that if there are a multiplicity of claims alongside a contractual claim, they all fall within the jurisdiction.
No, they've got to be linked.
If they're using the language of indissociable, yes,
Yes.
but linked, yes.
Both have got to arise out of, haven't they?
Well, quite a broad approach is taken here. As I say, it might be surprising on first blush that a consumer protection measure in one country that overrides express contractual terms, as the Austrian law did, therefore grounds jurisdiction. The claim is brought on the basis of that consumer protection measure that operates because there is a contract and overrides that contract. That seems to me to be the core of it. And Section 27 of our Financial Services and Markets Act is not as intrusive as that. It simply provides measures for the protection of existing pension assets.
Oh, I see.
It's a weaker piece of consumer protection. Paragraph 57, the court continues. The court has in this regard recently recalled the need to avoid, so far as possible, a situation in which several courts have jurisdiction in respect of one and the same contract. 58, the need is all the more compelling in the case of a contract, such as that in issuing the main proceedings, in view of the fact that the multiplicity of courts having jurisdiction risks placing at a particular disadvantage a party deemed to be weak, such as a consumer. It is in the interest of the proper administration of justice that the latter should be able to bring before one and the same court in casu, that of his place of domicile, and this is the key phrase, all of the difficulties that are likely to arise from a contract, which the consumer has been induced to conclude by reason of the professional's use of forms of wording liable to mislead the other contracting
Well, that's
party.
why I asked you if it arises from the contract.
So all of the difficulties, my lady.
Yes, but it's got to have as its central feature the contract.
Well, my lady, in respect of Section 27, it is saying this contract is one that
Yes, of course.
should be set aside.
It's because of the contract that you're...
Indeed.
Yeah.
No,
So
ground
the
one.
fact that Mrs. Dooley has got the claims that she has, and also as she was visiting Montague Smith's offices, she trips up. That wouldn't be the same thing, would it, in terms of a claim arising from the contract?
My lady, that one would definitely fall outside. Yes.
Yeah, yeah.
But these are claims that, in my submission, clearly are inextricably, to use a more familiar English expression, linked to the transactional relationship brokered by Montague Smythe and entered into with Castle.
Arising from the transactional...
I mean, this is
Can you
these are
just give me
people.
that phrase again? Arising from the transactional...
Transactional relationship brokered by Montague Smythe and
Thank you.
entered into with Castle. Every one of these investors goes from having a largely protected UK-based pension asset to having something which we think is much less valuable in Gibraltar. That is what's being arranged, and that's what's being done. And all of the difficulties arise out of Castle being a willing recipient of pension assets in the UK brokered through this unauthorised intermediary. That's where it all comes from. The Section 27 claim could not be more inextricably linked with the agreement, the relationship between Castle and the investors.
Okay.
And we'll look on, this is why the later authorities are relevant. They make it clear that tortious claims.
Yeah.
I'm conscious of the clock as well,
Yeah.
my lady.
We've got to give Mr. Hart his fair
Indeed.
opportunity.
Lady, indeed. So we'll mess. But Gabriel really, in many ways, as Lady Justice Carr suggested maybe an hour ago, might be enough for me to get home on both grounds 1 and grounds 2, and indeed ground 5. It really is the answer to many of the points here that we need to look at.
So ground 1, 2 and 5, you say?
Yeah, because in summary, ground 1, because a contract claim, proceedings in relation to a contract include the domestic jurisdiction's consumer protection measures. And
Sorry, that didn't make any sense to me.
Sorry.
My fault.
So ground 1 makes it clear that the proceedings in relation to a contract would include UK-based investors relying upon UK domestic consumer protection measures that deal with the consequences of that contract. So we say that falls within both contract and certainly the preliminary words in proceedings in relation to a contract. So it helps with ground 1. It assists with ground 2 on the specific invitation point. We get the Giuliano and Lagarde report, and we get very clear, as Lady Justice Nicola Davies has said, that in terms it looks like pretty clearly on the point about the application form is sufficient to meet the specific invitation test. And on ground 5 is the discussion of indissociable links. And here again, it's the idea that even though this Austrian consumer is suing a German supplier, not for breach of contract, but for something to override that contract, is something which is that those consumer measures are also indissolubly linked for the purposes of my ground 5. So Gabriel really is at the absolute heart of the appellant's case.
Okay.
Engler, which starts at page 135, is one that I think is relied on very heavily by Mr. Hart. I won't dwell upon it very long. It's basically a replay of Gabriel, except that Petra Engler, the claimant, just claimed the prize. She didn't actually enter into a contract with the German mail order company. And really the result is that she can't therefore get home under Article 13 at all because no contract results. So that's not really our case. But she did get home under Article 5.1. So it does, I think, illustrate perhaps the width of, again, contract. So I don't think we need to look at much of this. I mean, I think it was relied upon by the learned friend, obviously, for saying that one should read down Article 13, and that Article 13 is a specific aspect of Article 5.1. And it's certainly true that Article 5.1 involves contracts, and Article 13 involves consumer contracts. So there is a link. But I don't think that should be overstated. In my submission, the consumer contract measures can be interpreted on their own language. The link is probably between the wide approach of the European courts to what is a contract. And so the only sections I would probably refer to in the Court of Justice is probably 48, which adopts what, again, is Mr. Francis Jacobs as Advocate General, AG 38. The concepts of matters relating to a contract, as referred to in Article 5.1, is not interpreted narrowly by the court. So it's a broad European independent concept of contract that's adopted. So we don't bring the doctrine of consideration to the table, although I'm happy to adopt the European court's language in Gabriel of reciprocal and interdependence obligations. That, in my submission, is what the contract of services involved here. But paragraph 48 is helpful. The contract, even in Article 5.1, is not interpreted narrowly. And you'll see at paragraph 60 that despite not getting home under Article 13, she got home under Article 5.1. So still quite a consumer-friendly result in that case. When we turn to PAMA, which is a case on the regulation, I'm conscious of time, so I can't spend a great deal of time on this. What I would stress is that there is some reference to the fact that we do have a bit of continuity in respect to the European jurisprudence.
What is the principle from PAMA that we should take?
So that the paragraph 37, milady. So PAMA starts at page 158. Sorry, it's not paragraph 37. Sorry, paragraph 56. Apologies. just making the point that this is based on the regulation, or the recast regulation.
Where's the relevant wording of the regulation? Article 15, is it?
Yes, Article 17, maybe. But this is directed at. This is the modern test in advertising. So this is the best account really of the changes that are made to sort of make the consumer contract test more media neutral, more internet friendly.
My fault. I'm just lost. Why are we looking at the regulation?
Just very briefly, because what our submission is that what has changed in the regulation is obviously the language of specific invitation. What we say hasn't changed is the idea that the gateway or the test for jurisdiction is a one-stop shop. So there's continuity, we say, in respect of the overarching consumer protection policy, and in particular for my case, the idea that once you have a contract within the relevant European test, the consumer can effectively use his home jurisdiction as a one-stop shop for everything that arises out of, all the difficulties that arise out of that relationship. And so there's not very much in PAMA I refer to, except that the court does stress the continuity between the convention and the regulation. So you'll see that, perhaps start at 55.
Well, it also stresses the need to protect the consumer, the weaker party, which
Milady,
is the point
yes.
you made earlier.
Yes, indeed. So the things that continue are the consumer protection objective, which is made stronger by a slightly lesser threshold for the consumer to meet by having any commercial activities directed at a member state. And a lot of commercial companies didn't like this lowering the threshold, but it comes in. We say on our facts, we get over the higher threshold of specific invitation, but what remains constant between these instruments, and the European Court stresses this, is the overarching consumer policy of protecting the consumer, and specifically the policy that once it is within the consumer contract test, the home jurisdiction is a one-stop shop.
I'm just struggling, and it's my fault, but what does the regulation say? You said Article 17, but that's not what I'm seeing here.
Oh, because this is Article 17 is a recast regulation.
Yes, so I'm looking for Article 15, aren't I?
Oh, in this one, yes.
Right,
So you'll
the
see
wording we're looking at.
it is actually the same, I think, but it's you'll find it in the judgment.
Paragraph 6, is this it? Matters relating to a contract, in all other cases, concluded with the person, direct such activities to that member state or several state.
Yes, it's paragraph 6 of page 161, my lady.
Okay, so that's the wording we're dealing with here.
Yes.
And the operative part, as my Lady Justice Nicola Davies has said, in terms of principle, is where? Paragraph 55 onwards?
Yes, I mean, so the bit of that test, of course, is that it's actually in some ways, you might say the convention's language in the first few lines is actually wider. So remember our convention says, in proceedings concerning a contract, Article 15 says in matters relating to a contract.
Yeah.
So you might even say that the convention looks a bit more consumer friendly, but I think they've been understood by the European Court as being the same, and both leading to the one-stop shop approach. But the bit I was just looking at was 55, stressing the continuity between the convention and the regulation, and that's spelt out at 56 about, well, obviously take account of the changes. There's Lady Justice Nicola Davies says 57 points out it fulfills the same function of protecting the weaker party. And then the rest of it really is quite an interesting discussion of the new test, but it's not our test. We have the old test.
Okay.
But the point
You said there's authorities confirming that in matters relating to a contract is being interpreted as meaning the same as in matters concerning a contract.
well, those are my two later cases, yes.
Right.
So the key one here really is is reliant code. So this is dealt with its sub-length of my skeleton, but it's in the authority under 214. And again, it's worth looking at it. So this is on, I think, the I don't know if I'm correct. I think it's on the recast regulations, now Article 17. But it's the same language, I think, as Article 15 of the regulation. So we step up 2 every time, 13 in the convention, 15 in the regulation, 17 in the recast regulation. This is somebody dealing, I think, with petrol futures on an online platform. And so again, it's financial services protection. You'll see at page 215, the claim brought in the home jurisdiction, I think, of Romania, is that he was a victim of manipulation on the platform by the service provider. Most of the case really isn't relevant to us except for the 4th question. But just in terms of the domestic law that was being used by the Romanian claimant, it's at pages 223 and 224. And again, it's domestic consumer protection law and domestic financial services regulatory law that he's relying upon. So these are claims that there is a contract, obviously, with the online provider of platform services of dealing in petrol futures. But his claims aren't to enforce the contract, it's to use the statutory protection measures of his home jurisdiction on consumer protection and financial services regulation to his advantage.
Did you say it's question 4 that we've got to be?
So it's question 4 in the CJEU. So it starts at paragraph 58, my lady, page 229.
Yeah.
And again, you'll see at paragraph 59, again, the European Court, and this is the most recent of the 6 authorities, stressing the continuity in the interpretation of the provisions of the latter legal instruments, whenever those provisions may be regarded as equivalent. Now, the test of directed at is not equivalent. The test of what falls within the scope of the consumer contract test, in my submission, is equivalent. In fact, as I say, the language of the convention might be easier. And you'll see over the page of 230 quite extensive reference to Gabriel, a case on the convention, in this case on the recast regulation.
Well, it's the paragraphs we've been looking at.
So those are 61.
Well, it's Gabriel 56 to 58.
It is,
Yeah. So it's quite extensive reference to Gabriel. And in particular, you'll see the CJEU using the same phrase in 63 in the middle there. The latter should be able to bring before one and the same court all of the difficulties that are likely to arise from a contract which the consumer has been induced to conclude. And then again, the repetition of indissociably linked.
And your point is that although the wording of Article 17 is different,
Yes.
Materially, so far as the one-stop shop point is concerned, it's helpful.
It's been treated as equivalent, I think, lady.
So treated
as equivalent. So it's in the language of the European Court in paragraph 59. The prefatory words as to what the consumer contract gateway covers, in my submission, is equivalent under the convention, the regulation and the recast regulation. So we say there's continuity on if you can establish an agreement, which cause of action can you bring? No, sorry. Okay.
So it says, look, the bottom of paragraph 14 to 59 should be recalled that settled case law, since Regulation 2012 repeals and replaces Regulation 201 on jurisdiction, which itself replaced the convention, as amended, the court's interpretation of the provisions of the latter legal instruments also applies.
i.e. the convention.
Those provisions may be regarded as equivalent.
Well, lady, yes.
Right, well that begs the question. So thus it should be pointed out that Article 15, which corresponds to Article 17, applies only insofar as the action. Well, why does that help us in relation to Article 13 of the Convention?
Well, that bit doesn't, because the need for a contract is dropped, I think, in the recast regulation. But the point is, if it's equivalent, it's the same. And where I've been trying to stress the continuity.
Well, 61 says it's equivalent, I think. In addition, in the analysis of the first paragraph of Article 13 of the Convention of 27th September on jurisdiction and the enforcement of judgments in civil and commercial matters, which also corresponds to Article 17.
But then that's exactly the point.
Yeah, okay.
So the point is that on this particular aspect, if I can establish an agreement ground one, it's Reliant Co, which is the authority, basically building on Gabriel. Gabriel might be enough, but in my submission, we should be looking at Reliant Co as well, because it says in terms that it's the same or equivalent as to what causes of action can be brought once you establish an agreement between the business and the consumer.
What, and that's paragraph 63 in particular?
61, 63. And the point that I'm stressing in particular is that it's relevant to my statutory causes of action, but also to my tortious or joint tortious causes of action. We say those do fall within all the difficulties that arise from this situation. And you'll see at 67.
It doesn't say it arising from the situation, it's arising from the contract.
All
the difficulties arising from the contract, which you say lead to the situation.
Yes. So just looking at 67, Mr. Owl's action insofar as it was brought against Reliant Co Investments, with which Owl concluded a contract, it must be observed as apparent from the file before the court that the action is based inter alia on national provisions on consumer protection, that is to say the requirement of suppliers to inform, to advise and to warn consumers about the services provided and the risks to which they're exposed before concluding the contract. So these are quite detailed domestic measures in the claimant's home jurisdiction about consumer protection and disclosure by financial companies. The court continues, it follows therefore the subject to those matters which it is for the referring court to verify that the action is intended to establish the liability of the supplier for failure to comply with the pre-contractual obligations vis-à-vis the consumer party. Such an action must be regarded as indissociably linked to the contract concluded between the consumer and the seller, so that Chapter 2 of Section 4 of the Regulation 1215/2012 applies to that action. That conclusion is not called into question by the fact that the action brought by Owl seeks to establish the liability of the supplier inter alia for culpa in contrahendo, referred to in Article 2.1 of Regulation 864/207, applicable to non-contractual obligations. On the contrary, it should be noted that Article 12.1 of Regulation 864/207 provides that the law applicable to a non-contractual obligation arising out of dealings prior to the conclusion of the contract, regardless of whether...
That's a different point, isn't it?
Well, it is, but it's a culpa in contrahendo point,
yes,
maybe.
the 70, but I think
Yeah.
we get
You then get into the fact that the governing law of culpa in contrahendo is the putative proper law of the contract. That's the point I think that they're making. But that is by the by, as your ladyship says, that the important point is that all of what our civilian neighbours would call culpa in contrahendo, fault in bargaining, so for English lawyers, misrepresentation or non-disclosure issues, all of those types of claims are treated as indissociably linked to the contract for the purposes of jurisdiction. I mean, my view below was that Reliant Co was the end of the claimant's case, really, the respondent's case in terms of where it was, because it makes it clear that the consumer contract gateway, once it's opened, brings in everything, and we've been seeing as we go through the sequence of European cases, it includes consumer protection measures, financial regulatory measures, and what effectively are sort of tortious type claims for pre-contractual misconduct, all of which can be brought by the consumer in her home jurisdiction. So we say the judge ought to have read and given full weight to all the authorities, that he has not given Gabriel sufficient weight on this point.
Well, he didn't make a decision on indissociable.
I think that's right. I think he never gets there in the end.
And there's no respondent's notice, which suggests he ought to have reached a conclusion in any event, whatever the outcome on one or other claim, that there was the self-standing claims that were unaffected jurisdictionally.
Yeah. I mean, I just have to have the better of the argument, my lady, as I understand it on this point, for these purposes. And in my submission, I clearly do. And the materials before the judge and the authorities were before the judge. And it's open to this court in my submission to say that on the jurisprudence, it's clear there is a contract in this case. It's clear there was a specific invitation in this case. And it's clear that all the causes of action are inextricably or indissolubly linked with that transaction between the parties.
Is that the end of the authorities bundle?
I think I'm
far as
not
your
planning to refer
argument's
to too many more unless I have
Yeah.
to.
Can I just remind you of the time, Mr. Booth?
Indeed. I think
Unhelpfully in that regard, you refer to Adams in section 27.
Yes.
And that you say there this court assumed without more that there was an agreement for the purpose of.
Yes.
Do we need to look? Do we need
Yes.
to look at Adams?
We can have a quick look at Adams.
No, just do we need to?
Can we look at section 27 just so your ladyship see what the test is under the statutes, and then you can see what they were doing, so what they assumed they were doing.
Can we just finish off where we started? I'd invited you to say whether or not you'd finished with the authorities, and you said that there were a couple of others that you wanted to take us to. So do you want to take us to them now?
My lady, in fact, these are probably the ones I was about to take you to. So section 27 of FSMA.
Right, okay. So
just
where
on
do
this
you want
point.
us to go in the authorities part?
So we need to travel back
Thank you.
to page 57. It starts.
Right.
This is the Financial Services and Markets Act 2000. And there are a number of linked provisions. I think we probably just need to look at in section 26(3, just the definition of agreements, which is just, it means an agreement made after this section comes into force, and the making or performance of which constitutes as part of a regulated activity in question. And then
It certainly covers a contract that's got extra requirements.
yes, it needs to be a regulated activity. And then section 27. So section 26 deals with agreements made by an unauthorized person. So that would be, this would be the classic scam. Where, for example, if there was an agreement with Montague Smythe in this case, it would fall within section 26. Because they would be, if they made a contract. So their contract to get paid, I suppose, arguably is void under section 26. But because Castle is the third party, section 27 is what was at issue in Adams and Carey. And so what it says is that agreements made through unauthorized persons, this section applies to an agreement that is made by an authorised person provider in the course of carrying on a regulated activity and is not made in contravention of general prohibition.
But your short point is it refers to agreement. Agreement
Yes.
is defined, so it's got
Yes.
to cover particular regulated activities.
Yes.
But your point is it has to be...
An agreement. And so if one just turns forward to Adams and options,
So it says agreements made made through unauthorised persons by virtue of 1A is unenforceable against the other party.
that's right.
Yeah.
So in Adams and options, it was a UK-based pension provider and a Spanish-based unauthorised intermediary. And the key difference in this case is that it's a UK-based unauthorised intermediary, but a Gibraltar-based pension provider. But I think we can just skip to the chase in terms of there's quite a lot of technical argument about whether or not the agreements did involve regulated activities, which are all resolved in favour of the claimant. And the conclusion of paragraph 117, page 270 of Lord Justice Dooley is that the section 27 claim succeeds. And that's despite Lord Justice Newey, as I say in the skeleton argument, accepting there was quite a lot of, a mixture of agreement and trust.
I don't think I get much from 117.
No. It's the result really. So the point is that
a mixture of the agreement. I'm mixture of the agreement and the trust. Show me
Yes.
that paragraph.
that might be useful then. It is I think described in my skeleton. So he does get. There is some quite difficult discussion of this, and in fact.
Would it assist if you gave us the paragraph numbers and we can read them over the short?
Yes, I can give you the paragraph number quite quickly. It is paragraph 64. But it needs reading a bit of caution because in that case there was an agreement with a pension administrator and a trust relationship with a separate company that was the trustee. And
So where are the introductory paragraphs that you invite us to read, and then we'll go to 64 and we can get the background.
get the background to it.
So it's basic facts, paragraph 2 on to paragraph 34, the section 27 claims.
That's right. I think basic facts. I was going to say
Yeah.
I would invite you to read the basic facts.
All right, so we'll read 2 to 33.
And then and then 64
Yeah.
is important, but it just needs treating with a bit of caution because obviously, whilst he's accepting that there is a big element of trust in that case, in terms of right under the pension scheme, which is not quite directly on point here. It is a mixture of contract. It must be a mixture of contract and trust because there is both a scheme administrator and a trustee, and the net result of the case is that.
And is that what Lord Justice Newey found?
Yes, the net result is that the whole arrangement gets unwound.
Right, okay.
So the trust is reversed effectively. So for our purposes, we would say effectively that the primary legal relationship between the parties, both in time and importance, is the contract. And the contract is the parent to the child, which is the trust. The trust is there fundamentally as a property holding device.
Sorry?
The trust is there fundamentally as a property holding device for holding the assets in the pension. But the overall service provided by Castle, initial services of setting up a compliant pension, and ongoing services of maintaining a compliant pension and providing support and valuations, we say is fundamentally contractual.
Does it matter? I mean, I picked up, and the judge referring to predominantly this. I mean, that's fundamentally. I mean, it doesn't matter necessarily whether something is has primacy or not.
Yes.
If it is there, if
Yes.
there is a contract,
Yeah.
whether it's subordinate or primate, isn't that sufficient?
It's sufficient for my purposes today that there's a contract between the parties, yes.
Well, there's an evidential base for saying so. We don't have to come to the conclusion that there was or there wasn't.
It's just
whether or
that
not.
I'm better with the argument that
Yes.
there's an evidential base using
Yeah.
pragmatism and judicial common sense.
Yeah. Okay.
And this has all the hallmarks of a reciprocal relationship. It's not a classic traditional trust, where a friend of the family looks after assets and isn't even remunerated. This is a modern commercial professional relationship of pension provision.
All right.
And it's obviously governed by the respondent's terms and conditions, we say.
Yeah.
I think I've made my points in a perhaps not the best order, but there we go. I'm just conscious of the time, given that.
There's a lot more.
Oh, there's a lot more. I was going to go through the grounds one by one.
No. I mean, you've said everything you want to on the contract. You haven't touched the emails.
Okay, let's look at those.
The specific invitation. If that's you say the judge overlooked the emails. So
Okay, let's look at the.
I mean.
Well, the
maybe you
emails
want
I
to
thought
regroup and go through, but there's a. Isn't there quite a lot to take us to on specific invitation on the facts?
I can take your relationship to the emails. I assume you would have read those. I mean, they are just set the background, and they fall very much within the.
Well, do you place any reliance upon them?
I do, yes, in skeleton. So I sort
As
of.
my lady said, it may be thought that they've got some importance. So, where do you want us to go?
So these are in the supplemental bundle.
There are a lot of names here that mean nothing to me on the face of it, but Medlicott, Mr. Medlicott is claimant number 17.
Well, can
is
we
that
just
correct?
get to the page of the supplementary bundle?
Page 60.
Yes, thank you. Right.
Yes, Medlicott is a claimant.
Who's Rose Cavendish?
So I did set that out in the particulars of claim, the lady, the best that we knew. So
Right, so Cavendish Rose is one of the intermediaries, is it?
that's right. I think it's also set out in the. We mentioned, I think, in the particular claim, Mr. Gale, of paragraph 20, page 81.
Who's Mr. Gale? Is he on this document?
I think he's in one of the emails. So maybe the way to. So it is actually important. I think your ladyship's right. So the evidence that we put in below, just in case that hasn't been at the forefront of our thinking so far. So if we take.
So page 61 is from Montague Smith, rather than from Rose Cavendish.
Yes. So. If we just turn forward to 66 in the core bundle, in the supplemental bundle.
64, you say?
66.
Right. Okay. The witness statement of Mike Wilson.
Yeah. So, in the evidence below, so as he explains at paragraph 4 on page 67, the documents are largely taken from disclosure and responses to subject matters requested by the defendants. And then describes a bit about the background provided by Castle. But going 2 pages forward to page 70, he says, in the case of all the claimants, the QROPS and underlying investments were principally promoted and recommended to them by Montague Smythe, a Cypriot firm, which was not authorised by the UK Financial Conduct Authority. At the relevant time, Montague Smythe was operating from a UK address at 4 Redwood Court, Winifred Road, Waterville, PO7 0LE. And then 28, a few other unregulated firms and individuals, all from the same stretch of English Southern counties, have featured in emails relating to pension transfers in respect of individual claimants, including the following. First, David Gale, an accountant who I understand was convicted of fraud in respect of another investment scheme. He's linked to an address at Suite 24 in Chichester. That address is also linked to Castlemore and a Yancey Harvey.
And are all of these reprehensible persons, as Mr. Wilson would have us regard them, connected with Castle?
My lady, they are all connected with the process of these investors signing up with Castle. Yes.
With Castle, yes.
Yes.
Right, okay. So take us then to the evidence upon which Mr. Wilson relied.
So then we go back to the emails.
Yeah.
So this one is Rose Cavendish, or variously page 60, Cavendish Rose. It's a subject headed "Next Stage in the Process, Pension Transfer." So it first of all has investment docs for Aspero, mostly pre-populated, sign as a member. Declarations of self-certified sophisticated investors for Castle. Tick all the boxes, sign as a member.
But this doesn't give us any indication, does it, of how Mr. Medlicott has got in touch with... this doesn't give us any indication of how Rose Cavendish at first came to know about Mr. Medlicott.
Indeed, I mean that's...
No. So is there anything which does, which helps us on the direct invitation point?
Well, given the point that was picked out, I think, in Gabriel by Lady Justice Nicola Davies, each of this is part of the story in explaining how application forms and things were signed, and each of it would fit into that pattern. But
well, we know how application forms were signed in the sense that you've got obvious documentation which shows that certainly Mrs. Dooley and the others ticked relevant boxes, signed declarations and the rest of it. But insofar as the specific invitation is concerned, these are telling all of the relevant claimants to sign the attached forms, taking note of the following.
Well, do you say the documents at 1661 are specific invitations?
Well, they were put in for that reason, that they illustrate the process by which, or part of the process by which specific invitations were made to these investors, yes.
Well, these obviously weren't the first emails to go to these investors, were they? Because I'd hope that nobody would start an email to our rock god, Hi Martin, without some previous contact.
Your Ladyship noted that email address, yes. No, it's obviously... it is part of the process. I mean, they are relatively informal. They evidence...
you need to address us on what specific invitation means then, and what do you say it means? Does it have to be, as my lady suggests, the first formal invitation, point of contact made directly, or, and is there any law on this? Is it post-introduction, post-first meeting, please sign the following documents? What is it? What does it mean, specific invitation?
It means, my ladies, a specific invitation to do business with Castle. And that's...
So can it be halfway through a relation? It can be 6 months into a relationship. So Montague Smith, Claire, whatever, she's got in touch with Martin Ball. They've met for a couple of coffees and they've had some preliminary discussions. and then 2 months in, Montague Smith send this an invitation saying, please sign the following documents. Is that a specific invitation for the purpose of Article 13.3a?
Well, yes, but I think the analysis would be holistic and it would be contextual. It would look at the whole of the relationship and it would look at it in context. But
So by inference, you say there must have been something before that, and that must have been an invitation.
well, the entire so to take Milady's example, you could have a regulated or unregulated intermediary in the UK who has an ongoing relationship with an investor, and 6 months or 12 months in, they say, "Oh, this is a brilliant new overseas arrangement with this company."
So you're saying this could be the specific invitation announced to my lady?
Indeed, but I'd rather say it's the whole of the relationship between the business and its middle people, and the consumer, and one looks at it holistically.
Well, yes, I know, but there's got to be a starting point, isn't there?
Indeed, and presumably the starting point is reference to the specific overseas provider.
But the point is, Mr. McNeill, looking at Article 13.3a, we've got to look at the specific invitation being offered. And the concession's already being made. It could be to the occupier, here's a unique opportunity to invest in Castle, who are the best thing since sliced bread. But we're looking for that specific invitation, even in those terms. And so we can see that you've provided evidence that there was engagement between these people, but engagement doesn't necessarily establish the specific invitation, does it?
My lady, no, and that's why I wasn't going to go back to the emails. I saw them as very much background.
Where is your specific invitation then?
As in answer to my lady Nicola Davies, eventually the filling in of the application form proffered by the intermediary by Mrs. Dooley.
That handing over of the application form is the specific invitation.
Usually attached to an email, as in these, yes. So the provision of application forms
is the specific invitation.
Well,
that's what you rely on.
Yes.
Yeah.
So
the provision, it's completely my fault. I haven't.
No. So
the provision of the application forms.
Of the application forms and associated documents for signing. Yes.
Attention, please. Attention, please. This is the Incident Control Officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
Well, I think that says 2 o'clock, don't you, Mr. McNeill?
Hopefully.
The fact that it's 1 o'clock suggests things to me. As to
Attention, please. Attention, please.
But we won't take any risks.
This is the Incident Control Officer.
2 o'clock, please.
A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts.